I can see a variety of names popping up as I'm speaking. That will continue. People will be admitted to the event, but I want to make sure that we get started promptly. So I welcome everyone in attendance to our Judicial Appointments Board for Scotland, I'll call us JABS for short, to our outreach event on the role of a legal member in the First-tier Tribunal for Scotland. My name is May Dunsmuir. I'm a judicial member of the JABS and the Chamber President of the First-tier Tribunal for Scotland Health and Education Chamber. The JABS will shortly be opening a competition for legal members for the following chambers: the General Regulatory Chamber, the Health and Education Chamber, the Housing and Property Chamber, the Local Taxation Chamber, and the Social Security Chamber. This event this evening is designed to introduce you to the First-tier Tribunal for Scotland, to provide you with information on the role of a legal member, and to provide you with an overview of the JABS recruitment process. We are very fortunate to have a range of skilled and experienced speakers with us this evening. Lady Morag Wise, who is President of the Scottish Tribunals, Professor Derek Auchie and Mr Jim Bauld, who are both legal members of the First-tier Tribunal for Scotland, and Dr Geoff Garner, who is a JABS lay appointments advisor and who is engaged in this competition. I will shortly introduce the speakers in turn, but before I do that, please save any questions until after the presentations. Time has been made available for a Q&A session before the outreach event closes at 7 o'clock, and please use the chat function to ask any questions. You should be aware that the event is being recorded, and you will have received information about how to anonymise your name if you prefer to do so. That's all I want to say by way of introduction. I'm going to turn now to introduce Lady Morag Wise, President of Scottish Tribunals, who will provide an overview of Scottish Tribunals. Lady Wise.
Thank you very much, May, and I can see at least the numbers of people on my screen who are attending. It's super to have this turnout, so thank you very much for attending this webinar today and for your interest in the devolved tribunal system. I've been President of Scottish Tribunals for just over 18 months now, and it's been a real privilege to work with the Chamber Presidents in the Scottish Tribunals, more of that in a moment, and learn a little bit more about the work that goes on in each. As I hope most of you know, the post of President of Scottish Tribunals was created by the 2014 Act that devolved some tribunal work in Scotland. And I like to think of myself as a little bridge, because I am little, between the Lord President, on the one hand, who is the statutory head of Scottish Tribunals, and that's in the legislation, and then on the other hand, the business end, if you like, in the form of the Chamber Presidents and everyone who supports them. And I have regular and close liaison with the Chamber Presidents of each Chamber. Part of my role involves raising the profile of and understanding about Scottish tribunals, mostly with a view to dispelling any erroneous notion that they are the poor relation of the courts and tribunal system. And one of the key factors in that aim is to better convey and more publicly convey the message that all of those who sit in the devolved tribunal system as legal members, as you would be, are judicial office holders with all of the privileges and responsibilities that encompasses. So for those of you who are considering applying to be a legal member of the Scottish Tribunals, the first and really important message is that if you are successful, you will become a judicial office holder. And the implication of that, and I don't want to put anybody off because it's a good thing, is that the Statement of Principles of Judicial Ethics for the Scottish Judiciary states in terms that both ordinary and legal members of the tribunals are bound by the principles in that statement. So it's important work. What is it? What do the tribunals do? Well, the First-tier Tribunal for Scotland now has 6 chambers, and some of them have already been mentioned by me. We're going to be advertising for judicial office holders for 5 of them: housing and property, health and education, general regulatory, social security, and local taxation. The 6th one, which is general tax, is not going to be part of this competition. The Mental Health Tribunal for Scotland is a sort of separate pillar. It's the administration of it is carried out by the Scottish Courts and Tribunal Service, but it's not currently in the first-tier tribunal system. Now, it should be apparent, even from the titles of the 5 chambers that I've mentioned, that the work of the First-tier Tribunal for Scotland is very diverse. Some of us can recall well the days when, for example, eviction of tenants was litigated in the Sheriff Court through what we called recovery of possession proceedings. Well, that example, that is now a major part of the work of the Housing and Property Chamber. To take another example, the Health and Education Chamber deals, amongst other matters, with highly sensitive applications in relation to educational provision for children with special needs. Valuable and hugely important work, and I was very struck when I visited that chamber of the commitment not just of those who sit in it as judicial office holders, but of the administrative staff who processed the applications and liaised with the families. And they explained to me in some detail why they felt so closely connected with the work of their chamber. The General Regulatory Chamber deals with a number of transport-related appeals, charity appeals, and other matters that are coming in. You'll have seen publication of the LEZ extension, the low emission zones, and that sort of thing comes within the General Regulatory Chamber. Local taxation and social security may be more self-explanatory in terms of nomenclature, but in common with the other chambers, their work is very much on the increase, and it touches the lives of a significant number of people in Scotland. Some chambers are dealing with literally thousands of cases annually. Others deal with small numbers of highly intense cases with significant documentation. And of course, while it's not a competition by any means, you may be interested to know that more people in Scotland will come into contact with the tribunal system than the ordinary courts. So in a very real way, making decisions in this context will have an impact on the lives of members of the public. And the work of the tribunals affects how the civil justice system is regarded externally. So it's quite an exciting time to be part of this. It's a burgeoning organisation, and one that I hope some of you will enjoy. There is a briefing pack that's been prepared by Judicial Office in conjunction with the Judicial Appointments Board. You may hear more about that later, and I don't know if it's available yet, but there will be one which you can read more about the various roles depending on which chamber you were interested in looking at. Also, for more information on the up-to-date working of the devolved system, you can have a look at the Scottish Tribunal's annual report. And I make no apology for mentioning again that on the front cover of that this year, you will see the blindfolded Lady Justice. And this is there to emphasise that the tribunals, just as the courts are involved in dispensing justice impartially without fear or favour, malice or ill will. So I mentioned that the work of the tribunals is particularly diverse, and this is carried through to the way in which the different chambers conduct their hearings, and you may hear a little bit more about this as the evening goes on. Again, I've had the opportunity to visit various types of tribunal hearing rooms, and they're quite different, of course, from traditional courts. They are generally more accessible, less hierarchical, but they still retain the essential features necessary to reflect the importance of the decisions being made. The tone of any hearing in the tribunals will be set by those who sit on it and convene it. There is a respectable view that it is more challenging to convene a hearing where judicial office holders are not sitting on high imposingly, where their very presence on a raised bench signifies authority. Engendering respect and authority through language, courteous treatment of all users, and illustrating a shared desire to get it right is, I would suggest, a very rewarding way of being a decision maker, and that's the way in which it works in the tribunals. I know that modes of hearing in the Scottish tribunals are also diverse. There are telephone hearings when appropriate, there are hybrid hearings, and of course there are in-person hearings. There's a reasonable amount of scope for flexibility in tribunals' work, and I think it lends itself quite well to those who hold a number of positions or have what's sometimes called a portfolio career. There are 3 main tribunal centres, one in Glasgow at Atlantic Quay, Edinburgh at George House at the moment, and one in Hamilton. So there is scope for some flexibility in the locations from which you conduct the work. There's very good training available for those who apply successfully to become legal members of the First-tier Tribunal. And I'm in regular discussions with the Director of Judicial Training at the Judicial Institute about this. Some of the Chamber Presidents have created a bespoke tribunal craft course at which I gave an introductory address in February this year and also very recently. And I've been hugely impressed by the assistance this course provides to new members. It addresses all stages of a tribunal case, from application to hearing, to post-hearing and decision writing. There are also conferences laid on by some chambers. I recently addressed a social security conference at which quite overwhelmingly there were over 250 delegates, all of whom were really engaged in the issues of impartiality and inclusion, which was the subject matter of the conference. The chamber system also lends itself, I think, to one of more direct support from leadership judges like May Dunsmuir, from whom you've just heard. In the ordinary courts, it's sometimes said that moving, whether on a full-time or part-time basis, from being the lawyer advocating for one side to the decision maker is quite a lonely business, because you feel it's suddenly all up to you with no one to bounce ideas off or help you decide what to do. Now, of course, individual decision makers in the tribunals do take responsibility for their decisions. But I have found that the atmosphere in all of the chambers is a really collegiate one, and their relatively small size means that someone more experienced is always there to help. The principles that underlie the way in which tribunals do business are the same as those for all judicial decision makers. Legal members must act independently and impartially. I suggest also that they should be good at listening, and importantly, they must be even-handed. Many of the litigants in the tribunal system will be unrepresented. Some may be particularly vulnerable. Some may act inappropriately, badly even at a hearing. The skill of being able to deal with all litigants fairly and with suitable composure is a really valuable one, and I think it's useful not just if you plan a long-term judicial career, but dare I say for life generally. So I very much hope that some of you will apply to be part of the Scottish Tribunal's judiciary in here, that if you do apply, you're successful, and I hope if successful, you will then sit as often as needed, and that you will find it stimulating and rewarding. I know that we're going to go on and hear about some particular aspects of the journey towards tribunals judiciary and what it entails. I'm going to switch my camera off now, but I'll be here for the rest of the session And I'll put my camera back on in case there are any particular questions directed at me once you've heard more of the substance of what is involved. So thank you for listening, and I hope to see you again at the Q&A.
Thank you very much for that, Lady Wise. We're going to turn now to look at the role of legal members of the Scottish Tribunal. I'm going to speak for a little bit just generally around the role of the legal member, and then I will introduce our next two speakers. I'm very pleased to say that Lady Wise has done all the work for me, because much of what I want to say is an echo of some of the points that Lady Wise makes. But let me just hit some of those points now. So, a legal member, as Lady Wise has said, is a member of the Scottish judiciary, and the role of the legal member can be varied and challenging depending on the chamber, but it is always richly rewarding. I joined the Mental Health Tribunal in 2005 as a legal member, my first tribunal appointment, and I have to say I've never looked back. Tribunals are judicial bodies created by statute with their own specialist jurisdictions. They are independent and their decisions are legally binding. They operate differently from courts in that they are both adversarial and inquisitorial. This balance gives us a greater deal of flexibility in our proceedings, and that allows us to improve access to justice and to secure the best evidence. Tribunal rules of procedure are centred around an overriding objective which focuses on just and fair proceedings, flexibility in proceedings, equality of arms, and efficiency. The majority of tribunals for the chambers that we are about to run a competition for, in fact, the majority of tribunals, whether in the Scottish tribunals or not, are commonly made up of 3 members, 1 legal member and 2 non-legal members drawn from an experienced and specialised field. Some tribunals will sit with 1 legal member at times, and others with 1 legal member and 1 non-legal member at times. So what's the role of the legal member? Well, the role of the legal member is, I suppose, multifold, but I want to focus on a particular set of qualities. The first is that the legal member has to chair the hearing. And the next that I want to touch on is that the legal member ultimately has the responsibility for the drafting of the decision. And that is done with the support of the non-legal members. The legal members will also engage in any pre-hearing judicial case management, usually sitting alone, where that's a feature of a particular chamber. Apart from these features, the 3 members of a tribunal carry equal weight, and I think that's what gives tribunals their unique strength. They share the responsibility of reaching a decision, agreeing the reasoning for that decision, and communicating that decision orally and or in writing. The legal member will carefully lead and guide the stages of the hearing, from the pre-hearing stages through to the hearing itself and during the post-hearing process, and all of this in a collegiate and collaborative fashion. Before I turn to Professor Derek Auchie, who's going to be sharing his experiences as a legal member, I want to leave you with the words of, as she was then, Baroness Hale. Tribunals are ultimately, these are my words, I'll tell you when I'm quoting from Baroness Hale, but tribunals are ultimately masters of fact and decision makers. They're considered to be expert in their jurisdiction. And this is a matter which the superior courts respect. And now I will quote from Baroness Hale in the case of A.H. Sudan against the Secretary of State for the Home Department, a 2008 case. And she says, "This is an expert tribunal. charged with administering a complex area of law in challenging circumstances. To paraphrase a view I have expressed about such expert tribunals in another context, the ordinary courts should approach appeals from them with an appropriate degree of caution. It is probable that in understanding and applying the law in their specialised field, the tribunal will have got it right. They, and they alone, are the judges of the facts. And Lady Hale is a great advocate for the tribunal system, much like our President of Scottish Tribunals, Lady Wise. In closing then from me, if you want to join the Scottish judiciary and you're interested in developing your judge craft in expert and specialist jurisdictions, I would suggest that you can do no better than the First-tier Tribunal for Scotland. And with that, I will switch my own camera off now and I'll be available throughout the evening. I'll hand over now to Derek Auchie, who is a member of the Health and Education Chamber, the Social Security Chamber, the Mental Health Tribunal, and the General Regulatory Chamber. And Derek's going to share with you some of his experiences and thoughts on being a legal member.
All right, good evening, everyone. I hope you're well and welcome along. I'm delighted to speak to you tonight on the role of a legal member, and with particular focus on the Health and Education Chamber. The first thing I want to just talk about is my journey, and Lady Wise mentioned portfolio there in her remarks at the beginning, and I suppose that's what I've done since I started tribunal work 20 years ago. It's hard to believe it was 20 years ago, but I'm afraid it is. And I started in the Mental Health Tribunal for Scotland, as President Dunsmuir did. And I've really added on over those years a number of jurisdictions. I've been fortunate enough to be able to be accepted onto those other tribunals. And the reason I did that was because I enjoyed it so much. And what I've done really is I've reduced down other work that I've done and replaced it with tribunal work, because I've really got this appetite, had this appetite to do more and more of it, frankly, over the last 20 years. So that's what I've done. I don't want to dwell on my biography really too long, because I want to really talk about what I do as a legal member, and in particular in the Health and Education Chamber. And I want to really talk about four things. I want to talk about, firstly, the importance of the work in the Health and Education Chamber as the example that I'm giving, and Lady Wise talked about importance. Secondly, I want to talk about how stimulating the work is. I think Lady Wise used that word as well. I want to talk about decision making and the kinds of decisions that legal members in that jurisdiction make. That's three. And number four is the support that is available for Health and Education Chamber legal members. So the first is the importance. Let me just tell you the kinds of cases that we deal with in that chamber. There's four types. Well, in general terms, it's cases about education. So it's dealing with the educational future, really, of children and young people with additional support needs or disabilities or both. And there's four case types. The first is placing request references. That's where we're deciding whether a child or young person should go to a different school from the one they're currently attending, whether that's an independent fee-paying school or a school within the Education Authority's stock of schools, special schools. So that's the first type. The second type is about coordinated support plans. That's a special type document, a statutory status document, and it records in it the support that a child or young person needs for their schooling, and it records educational objectives for that support and who should provide it. And we have jurisdiction to decide whether or not the tests are met for that type of document to be created by an education authority for a particular child, or whether it should be amended, or whether the provision in it is not being met and it should be enforced. And we can make various orders around those types of cases. So that's the second type. The third is transition duties of education authorities, particularly post-school transition. So when a young person is leaving school, have the education authority done what they should have done to prepare for that child, for that young person to move on into work or in further education. And the fourth type is disability discrimination claims. under the Equality Act 2010, and that's a broad church, and those claims relate to whether there's an allegation of disability discrimination in relation to any aspect of education. It could be admission to a school, curriculum, examination, equipment, exclusion from a school, seclusion, restraint, just to name just a few of the examples of the types of cases we deal with. And our remedy powers are broad. We can't order compensation to be paid if we do find discrimination has occurred, but we can make orders around provision for the child to be, a young person to be changed, or we can even make broader remedies about training of staff or policy, changing policies that are in place by the education authorities. So those are the kinds of cases. So really, there's a broad range there, and it's important, I think, the work that we do, because when we are deciding whether to make a remedy or not, we're making a decision that could potentially affect a child or young person's who faces challenges in education. It could potentially affect their future in education, and therefore their future in life, I think it's fair to say, and also that can affect the allocation of resources for an education authority within its area of operation. So it's really important consequential work that we do. That's the point I want to make there. Number two is stimulation. Everybody wants to be stimulated in their work. I mean, who doesn't want to be? Well, there's no shortage of it in this chamber, I can assure you. The variety of cases that we have, no two cases are the same. I've been doing this job for 14 years, and I can honestly say I don't think I've come across two cases that are the same as each other in the 14 years. They're all different. They might be different in many different ways. Principally, procedurally, they're often different from each other, and also on the merits. And I'll come back to procedure in a minute. So there's no doubt about it, you will not be bored with the type of cases. It's far from a conveyor belt type jurisdiction, if there is such a thing. I've never, in all the jurisdictions I've worked in, you can never describe any of them as being that. But in this jurisdiction, you'll find that there is stimulation in variety. A second area of stimulation is really about the legal and factual issues. There's lots of legal issues to get your teeth stuck into. There's real decisions to make about statutory interpretation of what words mean, how they apply in the context of a particular case, and the factual matrix is usually reasonably complex and interesting. So that's the second point about stimulating work. The third is the views of the young person or the child. I mean, the UNCRC is now in force, you probably know that, but for a long time, certainly in the 14 years I've been doing this work, we've always been looking at the views of the child, trying to encourage the child to provide those views directly to us or to an advocate who then prepares a report, a specially trained advocate who prepares a report for the tribunal. And I have to say, some of the most interesting times I've spent in my tribunal work has been in having a child or young person along to get to share their views. Children and young people know what they want, by and large, and why they want it, and their clarity of thought, I think, on the whole, is sometimes much better than ours, and it's always a pleasure, a delight, in fact, to hear from them. And you'll do that a lot in this jurisdiction. And there's sensory hearing facilities in Glasgow and Inverness, and those are being extended. And so there's the infrastructure in place to allow us to take those views and to take them in an appropriate fashion. And then there's different types of decisions that you'll be making. So that's stimulating as well. You'll not just be doing the same thing all the time in terms of your decisions. And in fact, although I make that point under the heading stimulation, I want to move now to the third point, which is about decision making. There's two types really in this jurisdiction. The first is about case management. Now, as a legal member or tribunal judge, as it's sometimes called in this jurisdiction, you will be given your cases to case manage. You're given them at a relatively early stage once the pleadings have been lodged, and you're given your case, and it's up to you to case manage it. You decide when the hearing should be through obviously discussions and case management calls with the parties. You decide how many witnesses there should be. You decide what documents are to be allowed in or not. You decide all of these things and many more. You make the case management decisions. That gives you control over the work, and you can get some really interesting procedural questions. So preliminary issues, time bar or competency, etc., which you would, as a legal member, decide. So these are interesting. The procedural and preliminary decisions are very interesting, and you get to do those. The second type of decision you get is a joint one with the two other members. President Dunsmuir mentioned that a moment ago, how when you get to the hearing on the merits, you're in a group of three, a team really of three judicial officers. You'll be the legal member, and you'll have two specialist members who will come in this jurisdiction from either education or from health or social work. And they'll bring their own background. Now, it's quite refreshing and interesting to work with people who are not lawyers. Now, I don't have anything against lawyers, don't get me wrong. I'm one myself, and I know plenty of them, and there's plenty of them on this call, so I've got to be careful what I say. But it is quite good fun and interesting and stimulating, go back to that word again, to actually work with people who are not lawyers and who bring a different perspective really to the case. Not only do they bring their specialism to the case, so they can bring their own specialist knowledge, of course, and do to the decisions we make, they also bring just a different perspective generally, I think. And this tripartite system where you have three people from different backgrounds analysing the evidence and making a decision, that I think is a very strong structure within which to make important decisions. And it's a pleasure. Our colleagues are tremendous. They're very supportive, they're enjoyable, they're good company, and they're very passionate and professional about what they do. And they make a difference because crucial difference to the way the case is unfolds sometimes, because they will spot things that as legal members we're not qualified to spot. So we won't spot that there's a particular issue with the peer group or the curriculum or the assessment or whatever it is, to use these examples in Health and Education Chamber, and they will raise those issues. And of course they can't introduce their own evidence into the case, but they can use their expertise to direct some of the questioning on the issues that are already live issues. And that can be really interesting, and again gives that strength to the decision-making process. So that's the two types of decision-making, the procedural case management type decisions that you will do on your own, and then you've got the joint decision-making function at the hearing on the merits. The fourth thing I said I would talk about, oh, by the way, sorry, one other thing to say about the hearings, and I think Lady Wise touched on this. In this chamber, the Health and Education Chamber, the hearings are 2 or 3 days long, roughly. Sometimes 1 day, but usually 2 to 3 days, and sometimes longer. So I think Lady Wise alluded to that some jurisdictions are dealing with highly sensitive cases that maybe take longer, and other jurisdictions deal with cases that are dealt with on a shorter basis, with perhaps dealt with more quickly, if I can put it like that. And there's a mixture of that among the chambers. Sorry, I said I would move on to support, so I'll do that now. There's a significant, and again, Lady Wise has touched on this helpfully, there's a significant volume of support available to you in this chamber, and I think this is the same across all chambers. Of course, you are a judicial officer, and you will never be told what to do. Your decision is your decision, and you have the statutory independence, in fact, to make that decision. That must be, of course, protected. But you are, in this chamber and in others, offered a range of support, and I'll just run through a few of those examples. First is regular training. Again, that's been mentioned already. We in the Health and Education Chamber, we really put a lot of effort and time into the training that we provide. It's crucial. And we think about how to provide not just the content, but how to actually deliver it and make it interesting, stimulating again, but above all, useful and practical, so you can take the training away and apply it directly in your work as a legal member. And you'll get an annual conference. There's an annual conference every year for all members, and legal members get online evening training every year, and additional training for specialist issues such as dealing with unrepresented parties, or cases under the Equality Act. The second thing is you get a judicial mentor. That will be someone who will be an experienced legal member already doing the work in the chamber, and they'll be on the end of a phone or an email or a Zoom call or whatever to have a chat about anything you want, any cases that you're not sure about, or whether it's highly practical matters such as claiming fees, right up to discussions about how to deal with particular issues, always on the basis that, of course, it's your decision at the end of the day. The President's Office has an in-house legal member, that's myself, or a duty legal member, and of course the President, very approachable, and you know, we're always there to assist with any questions. That's in addition to the judicial mentor. President's guidance is very detailed and practical in this jurisdiction, as it is across the other jurisdictions that I've worked in, and that's a real go-to source to help you with the day-to-day work. We have in this jurisdiction, the Health and Education Chamber, Case Digest, which is a kind of textbook dealing with the kind of legal and practical procedural issues with case law, commentary, etc., and a decision writing toolkit to help you how to write your decisions with examples of decisions, samples and tips and hints, etc., to help you. Published decisions on a searchable database. The vast majority of the decisions are, of course, in a redacted form published, and so you can look at what other colleagues have done in terms of the style and the kind of issues that are covered in the hearings. Highly professional casework team, excellent colleagues who are always there to keep us right. They certainly keep me right, or they try to at least, in terms of how we operate our cases, and you know, the support that they provide really makes your job much easier than it might otherwise be, and regular updates on developments in law and practice by the President. The President produces updates on a regular basis. So you'll never be stuck. If you've got something, a question you need to ask, or a problem that you have, there will always be somebody there to help you, and that support structure is extremely strong, and it's certainly been helpful to me over the years. And I've been doing it for 14 years, and I was just in touch with the President the other day, she may remember, about a procedural issue that arose in one of my cases. So it's not just there for those of you who are at the beginning of your career in the chambers, in any of the chambers. It's there right through. You can contact someone even if you are experienced and you need some help. So I've talked about importance. I've talked about the work being stimulating. I've talked about the different types of decisions that you would make, and I've talked about the significant support structure on offer. If you like the sound of that, then apply to join us. Now, that's all I have to say. Thank you very much for listening.
Thank you very much, Derek. I'm going to introduce you now to Jim Bauld. Jim is a member of the Social Security Chamber and the Local Taxation Chamber. Over to you, Jim.
Thanks, May. I'm also a member of the Housing and Property Chamber, which is my main chamber. I thought I'd start as well, just very briefly, as Derek did, just explaining how long I've now been doing this. I've actually been a tribunal member since 2008, when I joined what was then the private rented housing panel. That has eventually become the Housing and Property Chamber. And over the years, it's added various bits to its jurisdiction. I was then assigned to the Social Security Chamber in 2020, although I didn't actually start sitting there until earlier this year. The assignations took place during the pandemic in anticipation of workloads increasing, and I was appointed to Local Taxation Chamber in 2022, and that was actually after going through this process, the JABS process, and going through an interview. And if I remember correctly, I think Derek was actually on my interview panel, so he's responsible partly for me being now in 3 different chambers. I'm going to look at eventually the work of the 3 chambers I sit in, just to give you an idea of the breadth and the diversity of the work that gets covered, that's already been mentioned by the other speakers. But I thought I'd just pick up on some of the comments that Derek made. He's mentioned the work being stimulating, and I would call it enjoyable, even as opposed to stimulating. He's mentioned it's not a conveyor belt, and I would agree with that. The cases are different. There are similarities, certainly, in one of the chambers I sit in, but every case is different people, different arguments. The work is challenging. Lady Wise mentioned right at the start of her talk, there's no suggestion that the tribunals are in any way the poor relations of the courts. We carry out significant judicial functions, and indeed, if I look at the Housing and Property Chamber, we got about 4 or 5 years ago the entire civil jurisdiction of the private rented sector from the Sheriff Court. We now deal, as Lady Wise said, with the private sector evictions that were once the province only of the Sheriff, and a whole range of other private sector tenancy disputes as well. In the Social Security Chamber, we deal with a range of benefits which are, subject to very complex legislation, complex decisions, and very significant impact on applicants. In the local taxation chamber, you're there dealing with cases which used to go to the valuation appeals committees. And just last month, I chaired a local taxation chamber hearing in which the assessor, the local authority, were represented by counsel. So if you think you're going to come in here and sit and just do very banal and boring stuff, I can assure you it's not. There is lots of very interesting and indeed very difficult work undertaken in these tribunals. Again, Derek mentioned the training and the support. Lady Wise mentioned she attended the conference for the Social Security Chamber just last month. I was one of the 270 delegates sitting there. Not only with Lady Wise there that day, we also had Lady Poole, Lady Carmichael and Lord Lake, 4 different senators of the college sitting there, and not just coming in, doing a talk for 10 minutes and then disappearing. They were sat there all day at the various tables with delegates. Indeed, Lady Carmichael at the end was on stage taking part in a very active question and discussion session, and was given 1 or 2 questions, but I think she very politely had to sidestep, but still gave very honest and upfront answers. So the training is there. Again, I think lots of solicitors nowadays, we tend to specialise, we get into our own wee narrow fields. I think if you join any of these tribunals, if it's out with your standard field of practice, you will very quickly learn the relevant law, the relevant cases, the relevant procedures of the tribunal to assist you. As Derek said, there is ample support from the President, from other members, and indeed Derek mentioned there the admin teams at the tribunals who are uniformly excellent, I have to say. Derek mentioned the idea of sitting there not with another lawyer, but sitting there with non-lawyers. I can tell you that those non-lawyers will occasionally come up with legal points, never mind other points, which even you won't have thought of. They will throw things at you that will make you just go, well, wait a minute, I hadn't thought of that, and really keep you on your toes. The general support you'll get in certain chambers, for example, in Social Security, there are a number of what are called duty or in-house conveners, and each of us have been given a group of members to act as a mentor, and they've actually been called your family, which I thought was quite strange. Before I was appointed an in-house convener there, when I was told who my family head was, I sent an email saying, "Hello, Dad." I don't think his reply maybe met the relevant standards that Lady Wise mentioned, but I won't say any more than that. Each chamber has got a very detailed website. If you want to know more about the work of chambers, please look there. I think Derek mentioned the chambers, many of them have databases of decisions, etc. You can look at that. And the recruitment, the case numbers in each chamber I'm sitting in is rising and shows no signs of stopping. So if anyone thinks there won't be any work, it looks as though that's not going to be the case. So if you are, as I say, interested in Tribunal Arts and Security, then please, when the applications go live, go and have a look and decide to make the application. Now, I'm going to look hopefully fairly quickly at the 3 different chambers where I sit. The first one, as I mentioned, the Housing and Property Chamber. I've sat there now effectively for 16 years. I should say, unlike Derek, we do not sit there as a team of 3. You will regularly be on your own as a legal member sitting alone in that chamber, and at best you will have 1 other member sitting beside you. In the eviction rent type cases, it can be either what's called an ordinary member, that's someone with a housing or a housing management background, or you can have a surveyor member, particularly useful when you're doing cases such as rent cases, etc. So generally you'll have yourself or yourself in 1 only. And Derek mentioned the health chamber, the hearings take 2 to 3 days. In the housing and property chamber, you will get only 1 case per day in certain parts of the jurisdiction, but in other cases, you will get up to 4 a day. You'll get a 10 o'clock and a 2 o'clock with an eviction and a payment action together. So you may have 4 cases per day there. Now, the Housing and Property Chamber deals, as I say, with a wide variety of work. We deal with the rent disputes, rent assessments across 3 different rental regimes in Scotland. We are still dealing with fair rent cases for what are called regulated tenancies that predate January 1989. So we are actually dealing with tenants who have been in their home for at least 35 years and sometimes substantially longer. We deal with the rent assessments for the assured tenancy regime, which ran from 89 to 2017. We deal with the current private residential tenancy regime. In each of those cases where there is a rent dispute, aside from doing the hearing, you will also be required to attend the property with your surveyor member to carry out an inspection. And you can be sent anywhere in Scotland for that. And I can tell you over the last 16 years, I have travelled to some very, very interesting spots in Scotland to carry out inspections, not just for the rent cases, but also for the cases involving what's called the repairing standard. In the private rented sector in Scotland, some of you will be well aware of this, there is a standard that private sector properties must meet. Landlords must ensure it meets that. If it doesn't, tenants can complain to the tribunal. We will carry out an inspection. We will decide whether the property meets that standard, and if it doesn't, we can then issue what is called the repairing standard enforcement order, requiring the landlord to carry out certain repairs. If those repairs are not done, we can then issue what are called rent relief orders, reducing the rent payable by the tenant until the works are carried out. So very significant work there. Another substantial element of our work is in the property factor section or sector. In 2011, there was a Property Factors Scotland Act. It introduced a code of conduct for property factors, and compliance with that code is enforced by this tribunal. If homeowners are unhappy with the conduct of a property factor and do not think the factor is complying with that code, they can raise complaints with us, and again we can investigate, carry out hearings, and we can make again what are called property factor enforcement orders, which can require factors to either pay compensation to homeowners or to remedy things that have not been done correctly, or take other steps to resolve the situation. The vast majority of the business of the Housing Property Chamber at the moment, as Lady Wise mentioned, is in the evictions and the associated civil proceedings, the payment actions mainly for rent arrears by landlords. Now, we now have the entirety of the private rented sector for eviction actions, and through the course of the COVID pandemic, the law in that underwent significant changes. Prior to COVID, there were many, many grounds for evictions in the private sector which are mandatory or automatic. If a landlord could show the ground applied, the tribunal, and previously the court, was obliged to grant the eviction order. That has now gone. Every eviction ground in the private sector in Scotland now has a reasonableness test. Every case you hear in evictions, you will have to consider whether or not it is reasonable to grant the order, aside from determining whether or not the landlord has one of the required statutory grounds. Do they intend to sell? Are there rent arrears? Does the landlord intend to live in the property, etc., etc.? So in every case, you're going to have to sit and discuss that with the other member. And again, you will have differences of opinion, and you'll need to resolve them and come to a decision. The civil proceedings involve quite substantial actions for payment. You can be dealing with rent arrears claims in the tens of thousands. You can be dealing with claims by tenants in respect of properties which suffer from dampness and mould, again running into several thousands of pounds, and with significant amounts of medical and specialist evidence being produced. There are other various other grounds or jurisdictions we have, including we have the letting agents. We deal with they have a code of practice. Again, we are there to ensure they comply with that. Another significant area of our work is still in the field of the tenancy deposit schemes. There was a set of regulations introduced again in 2011 requiring landlords, when they take a deposit, a security deposit in a tenancy, to place it with an approved tenancy deposit scheme. Incredibly, despite the fact we're now 13 years down the line, there still seems to be quite a number of landlords who are either unaware of these schemes or decide, for reasons known to themselves, they intend to avoid them. Our tribunal is there to deal with claims arising under those regulations, and we can award up to 3 times the tenancy deposit if it's not put into one of these schemes, and there are still significant numbers of that. Another interesting aspect of our jurisdiction, we also deal with landlord registration appeals. If somebody applies to be registered as a landlord and the local authority determines they are not fit and proper, we are now the appeal body, not the Sheriff Court, and effectively that is almost a near judicial review type action. Additionally, in our chamber, we deal with both wrongful termination orders and unlawful eviction actions, both of which can lead to significant awards of damages. And in addition to that, there are just numerous other minor types of applications, people wanting the terms of tenancy drawn up, a rent book issued, or assisting landlords to get into the property. So the Housing and Property Chamber has a tremendous width and breadth of the potential types of action, and the numbers that are coming through to that tribunal are growing year upon year. I think this year we've got going to be well over 6,000 applications to that tribunal alone. I also sit in the local taxation chamber that deals with council tax and non-domestic rates. In council tax, you'll get appeals about council tax banding, effectively people saying my house is in the wrong council tax band. Usually they say it should be in a lower one, not yet somebody saying it should be a higher one. And you get lots of that coming through. You also deal with cases of council tax liability, i.e. the calculation of the council tax, any exemptions such as students or discounts, single person discount, all of that comes to us, along with the council tax reduction cases, which again are effectively benefit appeals. People apply for a council tax benefit, the local authority determine it, person's not happy, we are the determining body. In that chamber, you tend to sit as a legal member with a surveyor member, usually a surveyor member with rating or valuation experience. And in the non-domestic rates, you deal with the valuation. People arguing my business property, my shop, my pub has been rated at a certain level. I don't agree with it. It should be rated lower. And again, you'll sit and make that decision. The most recent one I did related to an argument about the valuation of a garden centre in Ayrshire. The owners were arguing it was no longer effectively a garden centre, it was now a glorified tea room. The assessor arguing, no, it's still a garden centre, it's valued properly, and we had to sit and look at the expert evidence from the assessor about how you value garden centres as opposed to tea rooms, rural farm shops, etc., and then come to a decision. Finally, I sit also in the Social Security Chamber. It deals with a whole range of devolved Scottish benefits. We are now moving towards lots of benefits being transferred from the UK system into a separate Scottish system, and the Chamber deals with any appeals about that. So again, just a brief mention of what we do there. We deal with all the things that are called the Best Start grants, where our grants that are called pregnancy and baby payments, early learning payments, and school age payments. These are benefits payable to certain people if they get other qualifying benefits. These are additional funds they can get with respect of the birth of a child, the child's going to school, etc. Additional payments. We deal with funeral support payments. Again, if certain people on specific benefits and they're having to deal with a funeral of a relative, they can claim a grant for that from Social Security Scotland. And again, any appeals about that come back to our chamber. The most significant appeals that we deal with, however, are the child disability payment and the adult disability payments. These are the successors to what were personal independence payment and disability living allowance. They're now all been transferred from the UK system to the Scottish system, and numbers are increasing basically daily. Now, in the Social Security Chamber, we used to have 2 hearings a day, one at 10, one at 2. We are now moving to doing 4 every day, a 10, an 11:30, a 2 and a 3:15, I think the timescales. But in doing that, our chamber president has organised that we now will not require, in those cases, to do full statements of reasons. We will do a very short decision and a very short written decision on the 4 cases we get each day, and only if there's going to be a further appeal against our decision will we then be asked to write a full written statement setting out our reasoning for coming to that decision. I'm aware I'm getting very close to my time. May's about to cut me off. I would join with Derek in encouraging people to apply. I thoroughly enjoy the work of the Tribunal. As Derek said, as I've got slightly older, I am also, like Derek, have reduced the hours I spend in the office doing the proper work and fill other time doing Tribunal work in the different chambers. I'll also say, if folk want any, Derek mentioned about the support. If there are folk who, I'm sure the folk watching this, you know me personally, I'm happy to assist folk who want further information outside of this later on. May at that I will end and switch my camera off and await questions.
Lovely, thank you very much, Jim. So we've had a flavour from 2 legal members there who sit across the 5 chambers between them that are the subject of this JABS competition. I think it's time now for us to understand a bit more about what's actually involved in the JABS processes. And in order to do that, we're going to hear from Dr Geoff Garner. Geoff is one of our lay appointment advisors. He was appointed in 2020, and he will be sitting on one of 2 panels that are going to be set up for the purpose of this competition. Geoff.
Thank you. Thanks so much, May. Good evening, everyone. I'm, as May says, I'm a lay appointment advisor at JABS, and I'm going to be chairing one of the 2 panels for this competition. I'm going to talk to you tonight about the JABS recruitment process, and particularly about how you fill in the application form and how to prepare for the interview. The advert for the competition is planned to go live this Thursday the 28th of November, and it'll be published on the JABS website under vacancies. And included with that will be various legal role profiles that have been produced by the Judicial Office. There'll also be a guidance note from JABS, which gives more information explaining the various stages of the recruitment process. And both the role profiles and the guidance note will help you when you complete the application form. And a link to the application form will be published on our website. After the advert goes live, there'll be a 3-week window for applications. So up until the 19th of December, it will be possible to apply. After that, JABS will shortlist applications and we'll decide who we would like to invite for interview. And the interviews will be held in February and March. And our expectation is that we'll make recommendations for appointment in April next year. Full details of this and the whole process are on our website, and I will encourage you several times through this part of the evening to familiarise yourself with all the information. So let's start with the application form. There are four main parts to the application form. The first bit is the easy bit, the personal information, list of qualifications, your career history and eligibility. Then there are questions about your good character and conduct. The third part is suitability for the roles that you're applying for and your legal experience. And the fourth part is a self-assessment, which is split into two parts, both legal competence and personal and judicial qualities, and I'll come back to those. This last part is most people find the most challenging, and I want to tell you we want you to tell us about why you're applying for the roles, and then provide a number of examples that demonstrate each of the criteria that the board has agreed are important for tribunals. For legal competence, we're looking for evidence of strong skills and competence in your area of law, knowledge, interpretation and application of the law, and your ability and willingness to acquire new legal knowledge and skills. For personal and judicial qualities, there are four competencies. There's leadership and management, communicating effectively, exercising judgment and working with others. And each of those competencies has a number of sub-criteria which are listed on the application form. I want to emphasize, during the whole process, we are looking for you to demonstrate your legal competence and the depth and breadth of your legal experience, and also to provide evidence of how you match up to the required personal and judicial qualities. We're looking for you to give your best, and the key message is to read the guidance note and the role profiles on the website. Let's look at the legal section of the application process. The legal self-assessment asks you to give examples that demonstrate your legal skills and knowledge. Similarly, in the interview, there will be a practical exercise, a case study, where you'll be asked to demonstrate these skills and knowledge. But when it comes to scoring, only the legally qualified panel members will score these sections. The lay members, there are two lay members, two legal members. The lay members can read the legal material in the application form, and they're present throughout the interview, but they don't score these sections. However, they can consider the legal answers when they score other professional qualities, such as communication skills. On the application form, we ask you to indicate which chamber or chambers you're applying for and how you meet the skills and knowledge for those chambers. And at interview, there will be additional questions that are specific to those chambers. I want to talk about how we ask for evidence of the personal and judicial qualities, but first I want to give some practical advice about completing the application form. The first is, please do ensure you give yourself enough time to think about and then complete your application. Unless you're very experienced at this, it's not something you can just do in one evening, and I would really caution you against that. My advice would be to approach the form in sections, maybe dealing with legal competence on one occasion, then returning to complete the personal and judicial qualities section. I'd also recommend that you return to your draft application after a few days before you submit it to check with a fresh pair of eyes that you've covered all the things that we've asked of you. Applications are submitted via a portal on our website, and you can save an application in progress and you can return to it as many times as you want to. You can cut and paste from a Word document, and so another piece of advice is take the opportunity to use spell check. You would be surprised how often candidates do not spell check before they put their application form in. I would emphasize that we're assessing your written communication from the application form, so it's best to avoid bullet notes or note form. And I'd also mention that in the sections in the application form, there are word count limits. In the run-up to applying, it can be helpful to keep a note of interesting or unusual situations that happen as you go, so you're not having to think of lots of examples for your application or your interview all at once. The guidance note on the website will give you more detailed information about what's needed, and I urge you again to thoroughly read this. For each of the personal and judicial qualities, you'll be asked to give an example that demonstrates how you meet the criteria. You might feel that you can provide evidence in more than one example, which is fine, but it's good to remember that there is a word count, and therefore make sure you give enough detail for the panel to assess. It is important to read the question and answer that question. When panel members are scoring the application, they only can give marks on the skills based on the information that's provided. In answering the question, we want to know what you actually did in a particular situation. So it's best to avoid general assertions such as, I've always done something, or I'm known to be strong in this area, or describing your role, I regularly appear in the High Court, or talking about things that we did. These don't provide strong evidence, and it's more difficult to score. We need to know what you actually did in a specific situation. Give you a couple of examples. An applicant describes a case where they read a long expert medical report. They researched the medical background, they cross-examined the expert for a day and a half, and they got the expert to change their opinion. That's very impressive, but it doesn't tell us what the candidate's knowledge or interpretation of the law is. And on that information alone, we would find it quite difficult to score highly. Or to take another example, an applicant says that they have appeared in courts at all levels, from specialist tribunals to the Supreme Court. They say this requires knowledge and interpretation of the law, which no doubt it does. The judges they appeared before in these cases could assess that skill and knowledge. But the candidate has provided us with no information that we can make a proper assessment. So we simply can't give that candidate the marks that they would have got if they prepare the answer more carefully. What we need is one or more concrete examples of a situation that demonstrate and evidences the applicant's legal knowledge and skill. For instance, a candidate writes, excuse me, in one case, this point, which they would briefly explain, arose. My opponent quoted precedent that seemed to be against me. I researched how similar legislation was applied. I persuaded the court that the prior case law could and should be distinguished. That gives us much stronger evidence to assess. So I emphasize again, if we don't get relevant, accessible information, we simply can't give you the marks that you need to succeed in this process. Throughout the form, I'd encourage you to be honest about the gaps in your experience. Demonstrating self-awareness and insight is generally a strength. And if you can show that you've thought about how you might bridge those gaps, or indeed show what steps you've taken so far, all the better. There's a natural tendency, and it's quite understandable, to want to share examples where you've successfully achieved something. But sometimes examples that don't have a positive outcome can often be the best, particularly if you can show you've demonstrated your ability to reflect on why the situation might have turned out the way it did. So let's talk about the interview. We'll assume that you got through the application stage and you're shortlisted for interview. Please don't think it's enough just to reread your application, and please make sure you devote the appropriate amount of time to preparing for your interview. You will need to prepare for the questions that you will be asked. And it is very helpful if you don't use all of the examples from your application form in the interview. Think about what you can tell the panel at interview that provides more insight of your experience and skills. Past candidates have told us that typically they take up to a day to prepare for an interview. There's no hard and fast rule, but it certainly needs time put aside. So what about the process itself? The panel you'll be interviewed by will consist of 4 members, with a judicial and a legal member, a lay member, and a tribunal representative. Also in the room will be a note taker, and sometimes there will be a moderator who will also sit in. Their job is to observe and quality check the panel, so they won't be looking at the candidate. The interview will be in 2 parts. In the first part, there will be a case study focusing on legal skills and knowledge, whereas the second part will focus on the personal and judicial qualities. All of the parts are equally important, and we make no apology that this can be an arduous process. It needs to be, because it allows us to test your competence and gain as much as insight as we can into your potential for the role. At the application form stage, candidates can choose their own examples, so the panel is reading a wide range of information. And most candidates will choose examples from an area of law with which they're familiar. But at interview stage, we have to compare how the candidates perform on the same task. So we ask each candidate to prepare and present a response based on the same case study, whatever their background. There's no prescribed format for the case study. Each is suited to a particular competition. The case study is designed to let you show us at interview that you understand and can apply the relevant area of law, even if you don't have the prior experience. It's also designed to give no advantage to those with a particular area of law or with a knowledge of how tribunals work. The second stage of the interview is a general interview covering the personal and judicial qualities. There'll be the same qualities that were covered at the application form, and there'll be a mix of scenario type questions and then questions designed to test how your experience matches the required criteria. The questions will typically be, tell us about a time when such and such, or give us an example of a situation where such and such. And as I've indicated before, we're looking for evidence that we can assess what you have done against the criteria. We're looking for good examples, and they can come, as I said before, from situations that didn't go well, but show that you can reflect on your experience, and that can be very powerful evidence. It's generally better to use different examples in the interview from the application form, so we get a wider range of evidence to assess. And we definitely don't want candidates just to read out what they put in their application form. Finally, in the interview, we will ask questions about character and conduct issues that we need to be aware of, and we will confirm your understanding of the Judicial Code of Ethics and how you comply with that. It's important that you've given thought to those areas beforehand as part of your preparation. Just as there's a word limit for the written work, there is a time limit in the interview questions and in the case study. So for instance, in the case study, you may be given 10 minutes to present your response and 5 to 10 minutes to answer. We will strictly adhere to these time limits so that no candidate is disadvantaged or gains an advantage, and you can expect to be stopped at the time limit. This means that you should plan your answers in advance and make sure that you can say what you want to within the limit. We do recognise that the interviews can be daunting, and often even the most experienced people can feel under extreme pressure, so we will do our best to put you at your ease, but we know it's a very challenging situation. Just some final. This is a competitive process, and whilst your application will be assessed against the criteria, it will also be considered alongside other applications. So you need to give yourself the best chance you can to set yourself apart from others. You need to ask yourself a number of questions. How well have you understood the role? How would you make it work in practice? Would you be a good fit for the role? what will you bring to it, and how can you demonstrate your skills and knowledge and experience? And are you able to commit enough time to the process? Very final comment is, if you applied for a role before with JABS, please do take the time to read the information on the website for this particular competition. The application process is constantly being reviewed and revised and hopefully improved, and there may be changes in the format that will be different from previous rounds. So please read the information that will help your application. Thank you, and apologies about my frog in the throat, and I hope you found that useful.
Thank you very much, Geoff. That was very informative. So we've had an introduction to the Scottish Tribunals. We've heard the reflections of two of our existing legal members, and we've now had an opportunity to hear and consider the JABS process itself. We have a period of time remaining now to answer any questions or any comments that anybody would like to make. So I've checked the chat function. It is empty at the moment, but please do type fast and fill the chat function if you wish to. I would like to do a bit of a wash up of the range of information that we've heard tonight, and if there are no questions, it either means that your brain is brimming full of information and enthusiasm and you're desperate to get this process started. Right, here we are. Someone has asked, how long do you get to write up judgments? I can say in response to that, it very much depends on the chamber. Some of the decisions are made shortly after the hearing itself. In other jurisdictions, such as the Health and Education Chamber, you're given 10 working days, the equivalent of 2 weeks, to write up the decision, because you're writing a detailed decision in each and every case. There is a question here. I'm determined that I'm not the one that's going to answer all of these questions, but I'm going to answer this next one because it does say, is it a disadvantage if you have no or limited experience of tribunal work? And we are very keen in the JABS to encourage a wide range of individuals to apply for these legal member posts. So if you don't have experience of tribunal work, please do not let that put you off. Please do your best to explain why you think you're a good fit for this. I'm going to quote from Geoff, who said, give yourself the best chance to be compared favourably against others. So tell us why you would be a good fit. The next question, is there a minimum level of qualification to apply? There is. It's the equivalent of 5 years experience as a solicitor or an academic, or sitting across, excuse me, sorry, my screen's just corrupted. No, I'm back on. Lady Wise, your hand is up. Do you want to comment on that?
Yes, I just wanted to, in a sense, and I'm not involved in this particular round, I'm not on a panel or anything, but I have experience as a former member of the Judicial Appointments Board, and I have an interest, obviously, as PST in getting the best possible people to work as legal members. So I'd like to reassure anybody who feels that they have the requisite eligibility, that is a minimum of 5 years as a solicitor or an advocate, but whose practice may have been very different from the sort of work that you've been hearing about in which the tribunals are involved. The Judicial Appointments Board is very understanding of the concept of transferable skills. So you can get a criminal practitioner, for example, who has a particular interest in children with special needs, maybe because of something in their personal lives or families, and they would have a perfectly good case for saying, this is why, in addition to whatever work they carry out have carried out to date professionally, they feel they could bring something to the table in terms of applying for a particular chamber of the First-tier Tribunal. So just echoing what Geoff has said and encouraging people to apply who've never possibly been in a tribunal, but understand through sessions like this and other reading that you have something to offer. Please tell the board what it is you have to offer. There's a basic eligibility requirement, and beyond that, you know, it's up to you to tell the board what you can do. Doesn't have to be tribunal experience.
Thank you for that, Lady Wise. Right, and a couple of questions on practicalities, and I'll deal with both of these. How does it work in terms of maintaining your current role together with a legal member role? How would you recommend approaching your firm on that? I'm not sure I can answer how you should approach your firm, but there are many members of Scottish tribunals who continue to retain employment elsewhere, whether that's working for a legal firm or working for a local authority or the NHS or as an academic. Derek, I think, used the phrase a portfolio career. A number of legal members of the Scottish tribunals maintain a portfolio of work, and that includes their substantive employment together with their judicial employment. I think it's a very good fit in that respect. The next question is, how do these roles fit for those of us based in the north? Well, I can answer that very easily. Tribunals sit across the whole of the Scottish landscape, including the islands as well as the Highlands. And so you may be sitting on tribunals in the north, in the Central Belt, in the islands, wherever the business arises from. We've not mentioned the types of hearings that can be conducted, but generally those are either fully in person or fully remote, either using an online platform or a telephone system, or a hybrid version where you're doing part in person and part remote. So you could be sitting in a case, I could be sitting in a case up north, but actually, you know, working out of Glasgow at the time. And I'm going to ask Geoff to answer the next question. In terms of case studies at interview, are the studies issued in advance of the interview?
The honest answer here is we are still in discussion about the case study for this competition. It presents different challenges from other competitions in that the case study needs to address across all the tribunals, but we want to make it fair to everyone. However, if there is preparation work to be done beforehand, then we will send out instructions at a period before the interview to give candidates enough time to prepare. If we decide the case study doesn't need anything prepared, then you would be asked to come along, let's say half an hour before the interview starts, and you will be given a case study at the time. But we will treat every candidate the same.
Thanks, Geoff. The next question is what time commitment is required. That very much depends on the chamber that you're applying for. It varies from 10 days a month to 30 days, 10 days a year to 30 days a year. Although I have to say, as a chamber president, those who are available to sit more often will have the opportunity to sit more often, because all of the chambers in Scotland are all facing rising volume. So there will be a time commitment that you'll be expected to meet. That's set out in your terms and conditions. That would be the minimum time commitment you would be expected to meet. But if you do have more availability, I don't think there would be any problem in you actually sitting more often than that minimum commitment. The next question is in relation to the special case. The JABS has indicated in the Shrevell competition that's running at the moment that there is a special case that the First Division of the Court of Session is due to hear in relation to sheriffs. That is not relevant to eligibility for this competition. The eligibility requirements different for this competition. You'll find all the details on that in the guidance note, as Geoff has mentioned. So we went from no questions to a great flurry of questions, and I see, oh, I've got a couple more. How long do appointments run for? You're appointed in the first case for 5 years, and your appointment would automatically be renewed, provided the Chamber President and the President of Scottish Tribunals is satisfied that it should be renewed, and of course that you want it to be renewed. And for that reason, that's why I'm still sitting, having started in 2005, still here. Derek and Jim have both spoke about their duration. So many of us who join tribunals stay for a considerable period of time. And the last question I can see here is, can you bring any notes you have made into the interview with you? Geoff?
The answer is yes. For all competitions, people do sometimes bring in folders of various information. The only thing I would advise is not to read out from the notes. The notes are there as an aid memoir, and obviously you would have your application form in front of you.
Thank you. I believe, Geoff, we also provide notepaper and a pen just in case anybody wants to write. So if you do find that you're taking a wee moment to settle, take advantage of that notebook and pen, just to write things down, just to centre yourself and settle your nerves.
We are likely, if it's a scenario type question, what we have done in previous competitions is we've provided a printed copy as well as reading out the question, because we're not testing the fact that you can remember what was said.
Thank you. Right, okay, let me bring matters to a close now. What I'd like to do is just draw out some points from the speakers this evening. We started with Lady Wise, who reminded us of Lady Justice and judging without fear, favour, malice or ill will. This is a judicial competition. This is an opportunity for you to join the Scottish judiciary at a very exciting time in the history of tribunals as we expand our jurisdictions and our volume grows. Lady Wise also spoke about 4 characteristics of being a good legal member. She spoke about the importance of being independent, being impartial, being good at listening and even-handed. And I think that those are 4 matters to reflect upon if you decide to put an application together. We heard a lot from Derek and Jim about the wide range of subject matter that they hear across the chambers in which they sit, and Derek said no 2 cases are the same, and echoed Lady Wise's comments when saying how stimulating the work is. Everybody wants to find their work stimulating. I can say hand and heart, you will never be bored. It is always stimulating. I agree with Derek that no 2 cases are ever the same. Derek commented how interesting it is to work with non-lawyers, and he said, I'm going to quote him here, it's quite good fun and stimulating. So if you want something that's going to be fun as well as stimulating, as well as deadly serious at the same time, then this is for you. He spoke about the pleasure it is to work with the specialist members, and he and Jim spoke about the range of supports that are available across the chambers. I think that's something that's worth restating at this point before we close this outreach seminar. The range of supports are extremely strong across the chambers, and I agree with Derek that you will never be stuck. The chamber presidents and the offices that they create are all designed to be supportive for the membership, and the chamber presidents are very committed to making sure that our new members in particular are given as much support as possible. And that begins with very detailed induction training that you'll get over a specified number of days. Jim spoke about the training and the support. He also spoke about if it's out with your standard practice, you'll quickly learn. And I want to echo that point because it did come up in one of our questions in Lady Wise's remarks. If you have a heart for this, if you've got an appetite for it and you're able to learn, then this is an opportunity for you. I liked Jim's comment about non-lawyers often coming up with legal points, and I remember many an occasion where a medical member had quite the debate with me on points of law, and I have to say sometimes came close to winning the day. I won't ever admit to him winning the day, but came close certainly. That's how knowledgeable our specialist members become. Jim also mentioned the importance of our websites. Our websites are very detailed, and I would encourage you to have a look at the various chamber websites to see what's there. Geoff took us through the JABS process very succinctly and very well. I think that ought to at least have demystified some stages of it. But just to remind you, the first is information. Have a look at our website. The competition goes live on the 28th of November. It will run until the 19th of December. You will find there our application pack, our guidance note, the Judicial Office legal member profile, but also the individual chamber legal member role profiles will be accessible there as well. Geoff also spoke about the application process, the different sections of it, but he emphasised, and I want to emphasise this as well, that you must give yourself enough time to complete this. You really do want to sell yourself as well as you possibly can. You want to showcase all of the best of you. And let me tell you, I joined the JABS in May 2022, and I was quite astonished at just how hard the JABS worked to try to get the best out of candidates. So trust us that we will be doing the best to get the best out of you, but you need to do the very best for yourself in the first instance. Approach the form in stages, very wise advice. Check before you lodge it. Do it, don't make the last completion day, the minutes before you lodge it. Give yourself a day or two, check it again. Whatever you do, please proof it, please spell check it, because you are being assessed on the content of that application form. And Geoff mentioned that we're assessing your written communication. So if your application form is full of spelling errors or grammatical errors, that is not giving the best impression of your written skill. And finally, Geoff spoke about the interview and drawing from a wider range of examples and experiences than those listed in your application. That's not to say that you can't refer to your application, but you want to again showcase the best of you, so you will want to give yourself the best opportunity in that interview. And if I could just say before I move on to two final points, we are on the side of the candidate. We are not here to trip candidates up. We are here to try to find the very best in candidates through that interview process. So don't see your panel as for people who are looking to trip you up or who are looking for fault in everything. We are sitting there hoping that you will be able to demonstrate the very best you can in this process. I want to say something that no one has said so far, and I wanted to make sure I said this before closing this event, and I hope that those who this applies to hear this and hear it well. If you have applied for a tribunal legal member appointment in the past and you've not succeeded then, don't give up. Try again and try now. Why not now? You're doing you've taken the first step by coming along to this outreach event. I know many judicial office holders in courts and tribunals who did not succeed at first or second, or in some cases at their third attempt. They kept going until they got across the finish line, and they now serve as confident members of the Scottish judiciary. So please don't be put off by a less positive experience in the past, please approach this afresh. If you're interested in Scottish tribunals as a career, then now is a good time to go for that. There is one question that popped in just as I was speaking, which is, when is the next competition likely to be after this one? And I cannot answer that. All I would say to you is, this is a multi-chamber competition, which is an efficient way to approach matters. But given that 5 chambers make up this competition, we can assume that the expectation is that we will draw from this round sufficient members to see us equipped as well as we need to be equipped going forward. Chamber presidents are not in the business of wanting a JABS tribunal round every year. So we'll have been thinking and planning ahead. And so I would say, don't think to hold out. It won't be as frequently, I can say, as Shrivo competitions have been running. If you've been looking across the JABS competitions to date, there have been a number of Shrivo rounds. It's my view, unless Lady Wise wants to say otherwise, it's my view that that's highly unlikely for judicial office holders for the Scottish tribunals.
Yes, I agree with that, May, and I would just reiterate that all of those interested in this kind of work in the first-tier tribunal should be applying in this round for one of the many positions that are up across the board. Thank you.
Right, I don't think I've got anything more to say in terms of what's been heard tonight. So we will end this outreach session as thanking all of those who have come along, thanking you very much for your interest in this. That's an absolute delight to see, and wishing you all the very best of luck. I hope that many of you put applications together for this competition. But thank you very much and good evening.